Hello, I'm Tom Gilbart. I'm the head of the Inquest team at 19 John Street Chambers. And what the team and myself are doing at the moment is sharing some videos and articles with you, which we hope will assist our clients and solicitors with Inquest work. And today is a short video about a case called Smith. I'm just going to share my screen with you so you have the case name in front of you, and it saves me from reading out the name in full. I'm just going to call the case Smith from now on. This is a case which came out from a divisional court last month, and I want to spend a few minutes today going through some of the things which were discussed in that case. I'm going to just limit myself to general principles and not go into the details of the case unless it's necessary to do so. It's a sad case involving a death by suicide against a background of mental health difficulties. Now, I've presumed for the purpose of this video that the people watching it are familiar with inquest work and familiar with concepts such as records and reasons and Article 2 and the like. If you are an inquest practitioner, there are two good reasons why you should be familiar with what was dealt with in the case of Smith. Firstly, the court dealt with a number of different topics which come up quite frequently in inquests: causation of death, what should be put in the record, how to deal with expert evidence, and also the test for neglect. And I want to deal with those four topics. The second reason you should be familiar with it is that one of the three judges sitting in the divisional court on this case was the chief coroner. So the decision in this case amounts to the view of the leading judge, the leading judicial expert in the country, setting down what is expected as the approach to be taken in inquests. So what are the things you need to know from this decision? Firstly, the first topic that's examined in the case is the threshold for causation of death and the standard of proof for causation of death. What the court did was to go back to a number of recent cases with which you'll be familiar, including the decision of Lord Justice Leveson in the case of Tainton, and also the decision in the case of Chidlow. And the court in Smith, having reviewed those decisions and others, spelt out the following: that the question to be asked in looking at causes of death is not whether you can be certain that something contributed to a death. The question is, when considering a particular piece of conduct or a particular event, did it on the balance of probabilities more than minimally, negligibly, or trivially contribute to the death in question? That is now, of course, well established. It is, as I said, something which has been set down in a number of recent cases, but the divisional courts still felt it necessary to underline that as being the correct test. That suggests that other advocates are putting forward different tests and different formulations. Well, that is the correct one to use. As I say, the court went back to the decision of Leveson in Tainton. They looked at that formulation which I've gone through, and they also reminded readers of the judgment in Smith what was said in that case about Galbraith plus. A coroner is only bound to leave an issue to the jury if, one, there's evidence on which a jury properly directed could properly conclude the thing contributed more than minimally to the death, and secondly, that it would be safe for the jury to reach that conclusion on the evidence before it. So, no great surprises there, but you have the divisional court confirming that those three elements, more than minimal, negligible, or trivial, on the balance of probabilities, and Galbraith plus, are where you should be focusing your submissions when you are appearing at an inquest. The second topic that's dealt with in Smith is really a cautionary tale about expert evidence. In this case, an expert provided a report. That report came through before the pre-inquest review hearing, and the conclusions included that the death was preventable. Before the pre-inquest review, the trust who were involved in this case said they accepted what was said in the report, and they were taking action to deal with the issues that had been raised in the report. The position of the trust was that they therefore didn't see a reason for the expert to attend. His evidence could be read and or summarised. The family's representatives seem to have operated on the basis that that therefore should mean that the coroner accepted the conclusions reached by the expert. but that is to forget the nature of an inquest. An inquest is inquisitorial, it's not adversarial, and the coroner did want to hear from the expert. The expert was called, the expert was questioned by the parties, and the coroner didn't accept the expert's conclusions in quite the same way it's been imagined that she might. One of the complaints raised on appeal was that the trust had accepted what the expert had said, and therefore the coroner should have taken the expert's evidence as being that which was contained in the report made available before the review hearing. Well, the Divisional Court rejected that argument quite emphatically. Firstly, once the expert had given evidence, the expert's evidence didn't stand alone. It was to be considered along with the other evidence in the case and the other witnesses, and it was to be considered in light of the questioning which had been heard by the coroner. Secondly, it is for the coroner to decide what conclusions to draw. A conclusion isn't bound to accept the evidence given by a witness, and here, although the expert evidence remained strong in their opinion, the Divisional Court, which had read the transcripts of the hearing, took the view the coroner had conducted a thorough factual inquiry, and having done that, the coroner was entitled to reach her own conclusions and reject the evidence of the expert where it was appropriate to do so. So it's an important reminder of this. It's quite often the case that parties in advance of an inquest hearing may have no issue between them as to what is said by a particular witness, but it isn't their decision. This is the coroner's environment, and it's the coroner's decision as to the facts in the case and or the decision of the jury if they're sitting with one. So if you have a witness whose conclusions support your case, you can't presume that the coroner will go with those conclusions, even if it isn't challenged by another party in the case. You will have to be prepared in preparing your case, in preparing your questions, in preparing your advocacy. You will have to be prepared to demonstrate to a coroner why those conclusions are correct, if it is the case the coroner has sought to hear from that witness or that expert, even though there is apparent agreement between the parties. The third matter dealt with in Smith is what should be included in a record by a coroner. This inquest was an Article 2 matter, so the coroner was considering not just the means by which the death occurred, but also the broader question of in what circumstances the death occurred. In this case, there were criticisms to be made of the medical care given to the deceased, and in giving her reasons, the coroner accepted many of those criticisms about the medical care. What the appeal court, the Divisional Court, had to decide was the extent to which those criticisms, which had appeared in the reasons, should also have appeared in the record. Mr. Justice Griffiths, who gives the judgment of the court, describes how the court asked counsel for the family to draft what it was said should have been in the record of the inquest. And in a moment which will make many advocates' blood turn cold, it would seem that the barrister was asked to do this during the course of the court hearing itself, with the three judges sitting on the bench. What counsel included in the proposed record, which was then submitted, were phrases such as inadequate and below the level of basic medical care that a patient can expect to receive from a modern mental health service. Now, those matters which the family wanted to include in the record had been included by the coroner in the reasons, often using critical language. What the Divisional Court said in Smith was, firstly, both the reasons and the record were delivered in public. Both, therefore, are part of the public record, so it really makes little difference for the criticisms to appear in the record if they're already there in the reasons. Secondly, and more significantly, the court criticised the language which counsel sought to include in the record. They said, "We cannot approve language of this sort for either Part 3 or Part 4 of the record. As should be familiar territory, a coroner and or a jury is prohibited by statute from expressing any opinion or any other matter, except for certain specific matters. And it's not the function of a coroner or jury to determine or appear to determine any liability to apportion guilt or attribute blame. And a conclusion should be factual, expressing no judgment or opinion, and it's not the jury's function to prepare detailed factual statements." So that's a summary of what was said by the court in dealing with this question. But the court was reminding practitioners that even in an Article 2 case, any narrative verdict, any narrative conclusion is still expected to summarise factual conclusions briefly, and there's a prohibition on expressing opinions other than that particular list of specific issues, and that prohibition must continue to be respected. Then the Divisional Court had to ask, well, what if it's a case where lessons must be learned? The Divisional Court was quite clear that's no reason to add critical opinions to a record. Lessons needing to be learned might be a reason why a prevention of future death report should be prepared, if appropriate, but it doesn't mean that you can ignore the prohibition on critical language being used. The final topic which is dealt with by Smith was briefly the question of neglect, and again it's just a useful reminder from the Divisional Court, constituting as it did the Chief Coroner, as to how neglect should be approached. Firstly, a finding of neglect should be exceptional, especially in a suicide case. And secondly, there must be proof that not only was neglect causative of death, but also that it was in the nature of gross failure and gross neglect. So, the case of Smith is a useful one to have in your back pocket. There's the test to be applied for cause of death. There's the approach to be taken for expert evidence. There's the question of what should be included in a record or not included in a record. And there's also the issue of neglect and how it should be viewed. Now I'm going to show the disclaimer again on the screen. And just while that's being shown, a reminder to all of you that if there is something that we can help you with at 9 St John Street in relation to inquest work, then you can always contact us through the clerks, and you can see the email address for that at the top of the disclaimer notice. There'll be more of these videos and articles in due course, but for now we hope that you're all keeping yourselves safe in these strange times, and we hope to see you again soon. Thank you.